going to own a home, if you're going to cook, if you're going to live, you need to learn how to cook because you need to eat, and you need how to fix things because you need to know how to live in an environment. So, and they're both second degree black belts, so they can also defend themselves. In any event, ladies and gentlemen, I try to start these things on I try to put you all on a equal playing field because what we're about to do, I'm going to ask you to do something, which is, look, people seem to always need to throw mud because they think they need to demean the other side to make themselves win. Please don't. Give me the information I need to make a decent parenting time because once words are said, they are never taken back. You don't need to harm the other person. There is no winning in this. There are varying degrees of losing. That is all. I have to deal with when people are available, when the child is available, and how to deal with any property rights. So let us proceed. Miss Watts-Stay, your opening statement, ma'am.
Thank you. I don't really want to take a lot of time with an opening statement. The reality of this case is it's been pending for over a year at this point. We have two children between the parties. They are still relatively young. Mr. Granley has not had significant contact with the kids in approximately a year, in large part from our perspective, due to his own choices, behavior, and I guess how the case has proceeded. The issues before the court are going to be custody and parenting time, although as the court noted, I don't really think custody is going to be a disputed issue. My client agrees to joint legal custody. I don't think there needs to be a designation as it relates to physical custody. I think the issue really comes down to what is an appropriate parenting time schedule. As the court is aware, there is currently a supervised parenting time agreement that has been signed by the parties. The first parenting time visit under that agreement occurred just this past weekend. It's our intention to provide testimony that will go through the best interest factors to identify why that supervised parenting time agreement should remain in place at this point in time. Mr. Granley has a history of some mental health issues, seeking treatment, but not always maintaining medication. That's been a significant factor in this case over the last several months, is trying to obtain reliable information, which to date we have not received, about treatment, maintaining treatment, not utilizing marijuana while taking medication that would be contraindicated with the use of marijuana. We have text messages and statements from Mr. Granley himself acknowledging some of these as issues. So we believe that it's most appropriate to maintain the current supervised parenting time schedule for a significant period of time until Mr. Granley can show that he is under the care of a treating physician, that he is regularly attending those appointments, that he is consistently taking the prescribed medication with documentation to support that, and that he is not utilizing marijuana. Once that has been established for the appropriate period of time, then we are certainly willing to come back and review what parenting time would look like. My client will provide testimony with regard to the fact that throughout the history of the marriage, there has been a lack of consistency as it relates to Mr. Granley taking medication, maintaining a treatment program, and that he has continued to use marijuana, knowing that that has impacted the effectiveness of the medication. There will also be significant testimony regarding how that impacts him, and as it's related to that, then how he has interacted with my client and with the children. So we will provide all of that. The other issues, these parties do not have any real property. There are some financial issues related to vehicles, to taxes, to some insurance payments, and we will provide testimony and evidence as it relates to that. With regard to child support, I think it's important to note that we are over a year into this case. There is still no child support order. That was referred to the front of the court back in May. I do not know if Mr. Granley has completed the necessary documents, but we have not received any sort of recommendation. Regardless, Mr. Granley has not made a single contribution to the support of the children. Obviously not through any sort of court order because one doesn't exist, but certainly not in any sort of voluntary basis either, leaving my client to be the sole support for the children for well over a year because they separated in the spring of 2023, and he has not provided other than maybe some nominal amounts during the separation and prior to the divorce to the support of their children. He has also left my client responsible for expenses associated with some of the joint marital assets, which has put her in a financial hole that she's had to try to dig out of, all while I guess we don't know what he's been doing with his funds. We will provide testimony and evidence to the fact that he voluntarily quit a job that he had here during the divorce process or just before, and is now working what he claims to be a job making minimum wage at $7 and some cents an hour. So we are going to be asking the court to impute him to what his last wage was before he voluntarily quit that position.
That would be odd since minimum wage in Michigan is $10.25 an hour.
The defendant, Mr. Granley, lives in Indiana. I don't know.
Oh, never mind. No, I do know that one. I'm from Indiana, and that one hasn't changed in 30 years. So okay, never mind. That is $7.25 an hour.
Yeah. So we have provided the court with obviously our witness list, our exhibit list, an exhibit book. Those documents have also been provided to Mr. Granley. One of the exhibits that we have provided is a proposed judgment of divorce that has been circulated for several weeks. At the end of our case, we are asking that the court essentially enter the judgment of divorce that we have provided, which we think will establish, custody and parenting time that is in the best interest of these minor children, and addresses the outstanding financial issues. Obviously, I have attached some guidelines as it relates to child support, based both on Mr. Granley's past income, which he voluntarily left, as well as what I understand his current income to be, although I have not received any documentation supporting what that current income information is.
All righty. Mr. Granley, what's your opening statement, sir?
Yes, in this time, I have spent a year really focusing on shoring some things up in my own life. I feel like in this time that there's been some alienation that's happened with the kids. I am thinking that through this court process, it'll kind of reveal the financial things. Like I'm just looking for fair with the financials, and what I have done with my time for the boys has been trying to make sure that my mental health and my choices have been able to reflect that who I have chosen to be these last 12 months and who I have been in the past are completely different people. And so I'm excited to be able to share that with you. And that's it. Ultimately, this is just for the boys.
Okay, thank you. Ms. Watts-Day, you may call your first witness. You're the plaintiff's attorney.
Thank you. I would call Ellie Granley.
Ms. Granley, you may have to speak up. It seems like the speaker may not be picking you up as well as it picks up Ms. Watts-Day. Then again, she's kind of outspoken most times. So I didn't say that. I said you're outspoken.
I project my voice well.
There we go. Most theater people do. Thank you. For those that live in Indiana, I used to work at Holiday Star Theater and did some of the announcements. So where are you? I was looking it through the file, Mr. Granley. Where are you at in Indiana?
Columbus, Indiana.
Where?
Columbus, about an hour
Oh,
south of.
Plymouth. Yeah, never mind. I'm sorry. I grew up in Gary.
Okay, yes, sir. Well, I was just.
Okay. And then I spent 10 years in Crown Point.
Sir.
And I worked in Maryville at Holiday Star, where I used to do the announcements, which was good evening, ladies and gentlemen, and welcome to Holiday Star Theater. But in any event, you, Miss Granley, you are now sworn in. And if you could speak up now that we've taught you the lessons of projection from the diaphragm, ma'am, from the diaphragm. Okay, please proceed, Miss Sue Ann Watts-Day.
Your Honor, I guess I did want to address, if at all possible, I obviously provided to the other side and to the court all of our proposed exhibits. I don't know if Mr. Granley has any objections to them. I'm wondering if I can move to have all of the exhibits admitted, or if we're going to need to do this one at a time.
You're going to need to do this one at a time. I've learned my lesson in that. When someone presented me the same thing and said, I have 300 photographs, can I give them to you? And I was like, of before pictures of all the property, personal property. And then they entered exhibit number 2 as the after pictures, 220 some odd pictures of after property. I spent weeks matching before to after pictures in my courtroom, with no testimony and no cross-examination. So while I would love to just enter these things, what I found is the other example is somebody entered 500 pages of a psychologist's report. And I said, sure, I'll take it. I'll read it. I didn't realize it was double-sided and single-spaced. And nobody cross-examined on it. And this is a kid who couldn't talk to his counselor when the counseling started. He had to talk through his Mickey Mouse doll. So it was rough. So I'm sorry that you're going to have to deal with my lessons learned. We're going to go through each exhibit.
That is fine. So,
Okay.
And we are here on your divorce matter, correct?
Correct.
You know the defendant, Mr. Granley?
Yes.
When did you guys marry?
We got married September 12, 2015.
And do you have 2 children?
Yes, we do.
What are your children's names and how old are they?
Family, he is 3 years old and he is a year and a half.
And Miles was born after the 2 of you separated, is that correct?
That's correct.
Has Miles ever lived with the defendant?
No, he is not.
Okay. I'm going to go back, and I know I don't want to spend a lot of time on the history of the marriage, but I do think there's some relevant information there. How was the marriage at the beginning?
There was abuse that was present right at the very beginning of the marriage.
Okay. Is that something that you had experienced prior to the marriage, or is that something that started once you guys were married?
It started once we were married.
Can you please explain to the court what you experienced in the way of abuse?
There was multiple instances of explosive anger, and the abuse would come in forms of physical and verbal and emotional abuse.
Do you have some, I guess, specific examples that you can provide?
Early during our first year of the marriage, there was an instance during a fight that he pushed me down the stairs of our apartment. There was a time when we were driving, I was driving the vehicle. We were in
Ma'am, if I could interrupt, I apologize. Can you give me dates or months or time periods? When you start going through all these things, I need to know when they happened, approximately. I don't need to know exact dates, but if you know them, great. If you do not, I need to know, like, was this 3 years ago, 4 years ago?
Sure. The instance where he pushed me down the stairs, that would have been, if we were married in 2015, that would have been December of that year. So December of 2015 was when that incident took place.
Okay.
And then you were describing a time that you were driving?
Yes. Also within that first year, it would have been the summer of 2016. Argument when I was driving the vehicle, he was next to me. He grabbed my head, but grabbed my hair and was hitting my head against the driver door window until I said what he wanted me to say.
Were there ever incidences of, well, assault against you during the marriage?
There were multiple in the marriage.
And can you provide a time frame, or is this something that was happening consistently throughout the marriage?
It happened consistently throughout the marriage.
Did you ever call the police with regard to any of these incidences of domestic violence?
I did not know.
Is there a reason that you never called the police?
I usually reached out to his family, who I felt closest to at the time, specifically his mom. I was not trying to make any moves that would permanently damage him or have a big impact on his life moving forward. I was scared of making a drastic decision and tried to reach out to family instead for help.
So I'm going to refer you to as what I've identified as Exhibit 1. Is this an example of communication that you had with his mother with regard to this type of incident?
Yes, it is.
And can you summarize that for the court as far as what happened or why you had reached out?
Another fight argument took place that he became very explosive during the argument. He had stormed out. I called his mom because I wasn't sure what he was going to do next. So I reached out to his mom for help. And this is a back and forth between her and I of the issue that was going on. Not just that we were fighting, but that there was explosiveness, and I was not sure physically what he would do as a result.
And is she acknowledging that had been an issue that you discussed in the past?
Yes, she does acknowledge that.
I move for the admission of Exhibit 1.
Sir? Any objection, any comment?
No objection on that.
Okay. Your Exhibit 1 will be entered into evidence as Exhibit 1.
Were there ever times during the marriage where the defendant would remove your ability to communicate or somehow obstruct your ability to leave in any way?
Yes, there was an instance when we lived in Texas. It would have been 2018 that in response to a fight, he took my phone away from me and disabled our vehicle and then locked me out of the home.
Is that something that had occurred on more than one occasion, or is that just the specific occasion that you can recall?
It had occurred more than once, but that's the specific one that I remember.
Was there a time in August of 2019 that there was any form of physical assault against you by the defendant?
Yes, in August of 2019, again, through the results of a fight, he shoved me very hard back into a dresser, and I had a very deep cut and significant bruise as a result from that injury.
I'm going to refer you to what I've marked as Exhibit 2. There are two pictures as part of this exhibit. Is this a photograph that either you took or that someone took on your behalf?
This is a photograph that I took a few days after the argument.
Okay, and is that an accurate depiction? I guess tell us what that photograph is of, please.
That is a photograph of my back left hip that struck the dresser from that argument.
And is that an accurate depiction of what your left hip looked like after that argument?
Yes, it is.
I would move for the admission of Exhibit 2.
Mr. Cranley.
Your Honor, I want to make sure that I'm doing this the right way. If there's any kind of comments based on what's being said, is that to wait for later?
No, this is this what she says it is? In other words, your objections are She didn't take the picture. This wasn't what existed. That wasn't the shape of the, forgive me, her left hip at the moment. If that is, it's not objectionable. She says she testified. She took a picture of this. This happened at that time. It's dated August 16th, 2019, soon after the events. Now, you have the right to cross-examine, like maybe you can ask her, did you fall down the stairs
Okay.
afterwards? But, at this point, she's purporting it to be one thing. So the question is, do you object to the entry of what she took as a picture of herself?
I object to the situation, and I don't know if this is the time to talk about it or not.
You object to what?
Situational, that has been.
That's not the situation is allowed to cross-examine. The question is, was this the shape of her upper left lip on August 16th of 2019?
Okay, yes or no objection.
Okay, then that'll be entered as Exhibit 2.
And just to correct the record, Your Honor, I think you said, at least I thought I heard upper left lip, and it was
Hip,
upper left
hip.
Okay. Just making sure
Sorry,
we're on the
is
same page.
my tongue's wrapped around my eye teeth and I can't see what I'm saying? Is that the
Yes,
problem?
exactly.
Okay. But yeah, no, we've got two pictures of an upper left hip that appear to have an injury with quite a cut to the skin and some contusions, that is labeled on 10/22, morning or afternoon, I do not know. August 16th. Oh, AM, I apologize. And it was taken according to testimony about a day or two later. And this is a picture that she says she took. It will be entered into evidence at this time. Mr. Granley may question as to its inception, as to whether he's the one who pushed her down the stairs and that caused the injury, or did something else cause the injury? Please proceed.
Thank you. Was there a time during the marriage that Mr. Granley, to your knowledge, received any sort of diagnosis with regard to mental health issues?
Yes. Also in August of 2019, after the argument took place that I received the injury, I pretty much gave an ultimatum of he either needed to go and see a doctor about the explosive anger, or that I would be leaving the marriage. And then he did have a evaluation with a doctor at that time and was diagnosed manic bipolar.
And what is your recollection or understanding of what happened after that? Was there treatment that he received? Was there medication that he was supposed to go on? What were you aware of at that point in time?
He was prescribed Seroquel, and went through a process for the next 6 months to a year, finding the correct dosage that he needed of that medication to manage the bipolar.
And what has been your experience through the marriage with regard to his consistency in addressing mental health issues?
I had to be very involved with either making sure he had medication, picked up the refills, or was taking it daily. He would either forget or just not take the medication quite often unless I followed up on it.
Okay. At the time that this was occurring, sort of in that 2019, well, I guess just tell the court, when you guys got married, where were you living?
When we got married, we were living here in Michigan in Kent County.
And did you move after you got married?
Yes. After our first year of marriage, we moved to Texas.
And what took you to Texas?
His job.
What was the defendant doing at that point in time?
He was working for Steelcase, and he was a warehouse manager for Steelcase in Dallas.
How much was he making for Steelcase at that time, if you recall?
He was making around $55,000 a year for Steelcase.
Okay. Did he maintain that position with Steelcase the entire time that you were in Texas?
He had that job when we were in Dallas for the first 6 months. We then moved again in Texas, further south towards Houston, and then he went into the gas and oil field and got another job at that time.
Was the reason for the move due to employment issues, or what had caused the move?
He was wanting to break into the gas and oil field just for more income potential.
How much was he making while he was working in the gas and oil field?
He worked 2 different jobs during that time. The first one, I believe he was again around 55 a year. The second job that he had in that same field, he was making 80 a year.
During this period of time, were you also working?
Yes, I was.
What were you doing?
I was working as a vet tech.
Okay. And do you recall how much you were making?
I was making, I want to say 35 to 40 a year.
And I apologize. What year was this?
I think he asked what year was this?
What year was this?
This would have been between 2016 and 2018.
Okay, thank you.
And how long were you in Texas then?
We left Texas the summer of 2019.
And where did you move then?
Nebraska,
What brought you to Nebraska?
his job.
And what was his job at that point?
He just got a position as a youth pastor at a church in Grand Island, Nebraska.
Do you recall how much he was making while he was at Grand Island?
He was making 35 a year at that church at the time.
Okay. And did you have a job at that point in time?
I did.
And what were you doing then?
I was working as a medical coder.
How much were you making as a medical coder?
I was making 40 a year.
Okay. How long were you guys in Nebraska?
We were in Nebraska for 3 years.
Is there anything, did he maintain the same job that entire period of time?
He did.
Is there anything that happened in Nebraska that you would want the court to be aware of as it relates to the marriage?
The last the physical fight that happened in 2019, that was in Nebraska. After that, he was diagnosed as manic bipolar. He went on the medication, and things evened out. He was stable at his job. Things were stable at home for the most part. As long as he was consistent on that medication, things were in a much healthier place.
Okay. When did you leave Nebraska?
We left Nebraska the summer of 2022.
And what caused you to leave Nebraska?
We moved back home here to Michigan to be closer to family.
At that point in time, had your older son been born?
Yes.
And was that part of the reason for wanting to be closer to family?
Yes, both Chris and I, our fathers had medical issues going on. We wanted to be closer to our dads, as well as for our son CJ to have more time with our family.
When you moved back to Michigan, what jobs did each of you have or obtain at that point in time?
Chris got a job with Cornerstone Church as their youth director, and I was working for Corewell Health at the time as a medical coder.
Do you recall how much Chris was making as a youth director at Cornerstone?
He was making around 58 a year.
Okay. And is that the job that he held until he left that job?
That is correct.
Okay. And are you still with Corewell?
I am not with Corewell, but I'm still working as a medical coder.
Okay. And where are you currently working right now?
I work for Grand Island Clinic.
Is this the clinic that you had worked for in Nebraska?
That is correct.
So you're able to work remote?
Yes.
Okay. How much are you currently making?
I'm at 60 a year with Nebraska.
Okay. This is a little bit out of order, but if you can take a look at Exhibit 23.
A little bit out of order?
Little bit.
Out of 26, well, it's okay, 23 you said, correct?
Yep.
Yeah, luckily we all go to law school because we're not good at math.
This is
Okay.
true. Sometimes the testimony comes out differently than
Well, yeah, it always, I practiced this. I was a divorce attorney for 10 years before I got this job. So
I just don't want to forget to introduce the pay stub because I know you need it. So
yeah. Okay.
So
So her
Exhibit
her pay
20
chub, her
yes.
pay stub is exhibit number 23. Okay.
So is
And
this your pay stub as it relates to your employment?
This is, yes, this is through Eclat Health, and they contract me out to Grand Island Clinic.
Okay. And what are you currently making?
32 a year, or 32 an hour.
Okay, and do you know about how much that is annually? Are you working full time?
Yes.
Okay. So if I told you, I'm gonna do the math quickly for everybody.
bless you.
That was $66,560 annually. Does that sound right to you?
Yes, it does.
Okay. I would move for the admission of exhibit 23.
Sir, any objections? All right, that'll be entered into evidence at this time. Exhibit number 23 is now exhibit number 3 of the court. Okay, please proceed.
Ms. Granley, once you moved back to Michigan, did anything change in the marriage that, I guess, did anything change that you would want the court to be aware of?
At the point that we moved back, which was August 2022, I started noticing more issues of anger and mania from Chris. I related that to not taking his medication consistently, and that he was also using marijuana at the point that we moved back to Michigan.
What is your understanding of his marijuana use once you guys move back to Michigan, as it relates to frequency, et cetera?
I was unaware at the time how frequently he was using. I was informed later that from him directly that he was using marijuana on a daily basis at the point that we moved back.
Did you ever attempt to engage in counseling or anything else to address the issues that you were having in your marriage?
Yes, within 4 or 5 months of us returning, and I was seeing some of the abuse issues come back. At that point, I requested that we go to couples counseling, which we started in November of 2022.
Did you find couples counseling to be helpful?
It was helpful in bringing some issues to light. Our counselor informed me about 2 months in that she was no longer comfortable counseling us together because there was current abuse occurring at the time.
Can you please describe for the court what the current abuse was at that time?
Our counselor made note that there was mental and emotional abuse still occurring and possibly physical.
When you say possibly physical, what are you referring to?
She didn't have any specific evidence or instances, but she was concerned that if we continued with counseling, that she was going to put me in a compromising position that physical abuse would occur.
Okay. So specifically from what you were experiencing, were you experiencing physical abuse at that point in time?
No, it was verbal and mental and emotional at that time.
Okay. When did you become pregnant with Miles?
In December of 2022.
Okay. Did that change from your perspective, your viewpoint on the marriage, or how you wanted to move forward?
I was still doing my best to repair the marriage and move forward as best as we could without getting to the point that we were before with the physical abuse occurring.
Okay. Did there come a point in time where you came to the realization that you could not continue as you had been?
Yes.
When did that occur and what had happened?
We had a fight, a disagreement in June of 2023. The result of that fight was a physical anger outburst from Chris. He went into the other room at the home after cornering me and intimidating me in our room. He went to the room next door and was tearing things off the walls and flipping furniture. He later stormed out of the house, and I called one of my friends for help to come get me because he did not leave me with any way to leave the home. He took the keys for both vehicles. And at that point, I decided that I need to go live with my parents.
Was CJ present during this incident?
During the verbal argument, CJ was in the room with us. When Chris first walked out, I went to put CJ down for his nap, which was in the room next door. Then Chris ended up destroying the other room while CJ was in the home, but not in that same room.
I'm going to ask you to look at tab 3, which we are going to refer to for court purposes as proposed exhibit 4.
Okay.
Can you please describe, I believe there are 3 pictures there. Can you please describe what those pictures are?
I apologize. Which exhibit is this?
In your book, it would be tab 3. I don't know how you want me to refer to them now because I'm off.
Well, it's going to be, they're labeled from your exhibits, and I'm going to have to mark them as what the court has accepted them as.
Yeah. So it's exhibit 3 as far as my exhibit.
Okay. Then I've got them. All right.
And I guess first,
Mr. Granley, do you have them?
I do.
Okay, good. Then we're all looking at the same thing. Please proceed, Ms. Watts-Day.
Thank you. Ms. Granley, did you take these pictures?
I did.
And do you know approximately when you took these pictures?
I took these, it would be June 17th was the day that this argument and the day that I moved out.
Okay. Can you please describe for the court what each of these pictures represents?
This is what he did as a result of that argument in the bedroom that he was staying in at the time, which is right next to the main bedroom. He had ripped the shelf off of the wall. You can see the support bar for that shelf is, the metal bar is bent. All the pictures that were on the walls, he tore off of the walls and threw on the floor. The second picture is just he threw things around in the room as a result from the outburst. The third picture is in our living room. On his way out, he just started throwing things around and flipping furniture.
So that's I'm assuming it's a coffee table of some sort. That is something that he actually just flipped.
Yes.
Okay. We move for the admission of my exhibit 3, which will be the court exhibit 4.
Mr. Granley. Mr. Granley?
Yes, sir.
Any objection? Any comment? Okay. So exhibit number 4 will be the proposed exhibit 3.
Thank you.
Thank you for describing that. I was trying to figure out what that big white thing was in the middle of the floor. When you said it was a shelf, I was like, okay, now I get it. Okay. A little confused. Sometimes pictures do not comport with what you're looking at. So, all right. Please proceed, Ms. Watts-Day.
Thank you. Did you communicate with the defendant's mother after this incident?
Yes, I did.
And what was that communication? Can you sort of summarize what the conversation was?
That was her pretty much asking what exactly happened that led me to move out of the home to my parents. I told her a brief summary of the argument and Chris's outburst and reaction to it. I told her based on previous things that had happened in our marriage, I did not feel safe staying there. I was 6 months pregnant at this time, and that I needed separation. I needed some time away, and I was going to go stay with my parents.
And if you look at what's marked as Exhibit 4 in my binder, is that the text correspondence between you and the defendant's mother?
Yes, it is.
We move for the admission of Exhibit 4 as
Mr.
court
Granley.
Exhibit 5.
Oh, 4 and 5?
No, I'm saying as court Exhibit
Oh,
5.
as court exhibit. Okay, sorry. I apologize. Mr. Granley, you have those, you've looked at them, so do you have an objection, or is there what, sir? No objection. So proposed exhibit number 4 will become court exhibit number 5.
Thank you. Ms. Granley, so you were approximately 6 or 7 months pregnant at that time, correct?
That's correct.
Were you fearful for your safety on that day?
Yes, I was.
Were you fearful for the safety of your unborn child?
Yes, I was.
Were you fearful for the safety of CJ?
Yes.
Did you observe CJ to be impacted by this incident?
During the argument, when there was back and forth between Chris and I, you could definitely tell that he was aware and impacted by it. He kept crawling into my lap, trying to get my attention and help me calm down. I was having trouble breathing, and CJ was very attuned to that.
Thank you. So you moved out of the house on June 17th, correct?
Correct.
What occurred on June 18th?
On the 18th,
did you have access to a vehicle at that point in time?
no. So when the argument happened on the 17th, Chris took both keys to both vehicles, so I was not able to leave. I had some friends come over and help move me and CJ to my parents' home. And then the next day on the 18th, Chris sent me a message saying that I could come get the keys to one of the cars and get the car seat that I needed as well.
Which car did you end up taking at that point in time?
I had told him I was okay taking whatever car. He texted me that the Cadillac CTS was ready for me to take.
And when you obtained the Cadillac, did you have to do anything to it to make sure that it was safe and drivable?
Yes, I did.
What did you do?
The oil hadn't been changed. It was past due date for the oil to be changed. There was a significant smoke odor in the vehicle that I had to clean. The headlight was out, and I think that was it.
Okay. What was your understanding about what the defendant was going to be doing at that point in time? Where was he going to live or stay, to the best of your knowledge?
I had informed him I was going to my parents and that he could stay in the home we were renting at the time. He informed me that he was going to be living out of his vehicle instead.
Did you consider that to be rational behavior?
No, I did not.
And why was that?
There was no reason for him to live out of his vehicle. I was going to my parents. The home that we were living in was free. I was not going to be there. There was no reason for him to live out of his vehicle.
Did the defendant ever tell you that he was planning on moving to another city?
Yes, at one point he said that he wanted to move to Ann Arbor and apply for jobs there.
Do you know if he ever did that?
I do not.
Okay. At this point in time, was he still working at Cornerstone, to the best of your knowledge?
Yes, he was.
Okay. Were you having experiences, or were you experiencing issues with the defendant being dishonest or not being truthful about things?
Yes.
Do you have any examples of that?
The weekend that I moved out, that this fight happened, he told me that he had found a puppy in a ditch, and decided to bring him home. Later found out that he had went and bought that puppy, in a rash decision making of also living out of his car, and then he ended up giving that puppy to another friend.
Okay. And I'm showing, or I would like you to just take a look at Exhibit 5, what's marked as Exhibit 5. Is that correspondence between you and the defendant as it relates to the puppy?
Yes, it is.
Okay. Was that really concern to you about the puppy, or was it an issue with regard to concern about his judgment?
Mostly concerned about judgment. At that point, he was still saying he was going to live out of his car. So to go pick up a dog out of the ditch, or as I found out later, he went and bought the puppy, was just another sign of manic behavior.
Immediately after all of this did you ever facilitate parenting time between the defendant and CJ?
Yes.
And what did you do to facilitate that?
Offered multiple times for visits with Chris and CJ.
Okay. And did he take advantage of those? What generally occurred?
In the time between June when I left and October of 2023, he had CJ for at least 2 days out of the week that he would get significant time with him. After October of 2023, there were other instances that occurred, and we moved to supervised visits during that time.
Okay. Was there a point in June of 2023 that you became aware that Chris went to Pine Rest?
Yes.
And what was your understanding of how that came about?
My understanding was that he went over to our friend's house. See what day that was. On June 20. So 3 days after I left the home, he went over to our friend's house, and he ended up telling our friends that he was suicidal and he was thinking about driving his car off an overpass. They then encouraged him to go to Pine Rest and get evaluated or admitted.
Do we have an approximate date or time, month of that occurrence?
It was June 20, 2023.
Thank you. I got it was summer. I didn't know what year, but thank you. Please proceed. I apologize for interrupting.
No, that's okay. Do you understand, was he admitted at that point in time?
They wanted to admit him as inpatient. From my understanding is he protested that because it would interfere with his work schedule. So they offered him instead to do an outpatient program where he would come back during the days and be there during the days for a treatment program.
To the best of your knowledge, did they suggest a safety plan?
Yes, they did.
What was part of that safety plan?
Chris had a significant amount of firearms in the home. Part of the safety plan was handing over all of those firearms to one of his friends so that they would not be in his possession.
And did that ever occur to the best of your knowledge, and when?
Yes, June 21st, so the day after he went to Pine Rest, he gave all of his firearms to his friend, Vince.
I'm going to refer to what I've marked as Exhibit 6. Can you please take a look at that exhibit and I guess provide a summary to the court as far as what that is?
This is a text from Chris to me that he sent as a result of his time at Pine Rest. This is what their evaluation and what they suggested that he do moving forward, what he needed.
And specifically, it states that he should be taking the Seroquel, correct?
Correct.
At 800 milligrams.
Yes.
And then Xanax as needed.
Correct.
Is there anything on there with regard to THC, marijuana, or alcohol use?
Yes, specifically alcohol was never that much of an issue, but they did say that the THC and marijuana usage needed to be less than 5 times a year, and he needed to inform people around him when he was using.
And again, at that point in time, what was your understanding of how much the defendant was using?
He was using daily.
Okay. I'm going to request that this be admitted. So it would be our Exhibit 6, admitted as the Court Exhibit 7.
No, Exhibit 5. You did not enter the last exhibit.
Oh, I'm sorry. Then I do want to request the admission of our Exhibit 5 as the Court Exhibit 6.
And that would be the picture of the puppy,
Correct.
which was a brindle. Sir, any comment about Exhibit 5 on the brindle pup?
You're muted, Mr. Granley.
Oh, I thought I was muted. I tend to do that. This darn fob is right at my elbow, and I keep hitting it.
No objection. Thank you.
No objection to the brindle? All right. Okay, I gotta ask, is the brindle pup doing okay? Sorry.
With my former HR manager, Shea. So I gave her to our HR manager at the church we were at. And
So
her name's Bogey and hangs out with her husband all the time.
good. Okay. Sorry, I gotta ask, especially since I'm babysitting the grand dogs. Now as to exhibit number 7 or
Yes.
6 as
Our
exhibit number 7.
6. Yep.
Okay, sir, that's the email from you. I will say it's got to be from somebody other than the hospital because Seroquel is misspelled. But any objection to that one, sir?
No, Your Honor.
That's the one where you admit to the plan is to keep you on Seroquel and some Xanax. THC and alcohol should be less than 5 times a year, but there was no game plan to replace the nicotine. There never is. But there's no major change for you out of up dosage and commitment to limiting THC.
Yes, sir. There was no medical changes planned for that.
Okay, but any objection to the entry of that as because you texted it to her?
No objection.
Okay, that'll be entered into evidence as exhibit number 7 for the court. I'm glad to hear the brindle puppy's doing well.
Thank you. Moving forward, what is your understanding of the defendant's marijuana use following this interaction with Pine Rest? Do you understand that it stopped, or?
From Chris's report, the understanding was that he had stopped using.
Okay, so I'm going to refer you to Exhibit 7. What is this exhibit, if you could provide a summary to the court?
This is an email receipt that I had received in July. It would have been for July 4th that he had gone and purchased more marijuana.
Okay. We move for the admission of Exhibit 7 or the court Exhibit 8 at this point in time.
Yeah, Mr. Granley, what is your input on exhibit number 7 as exhibit number 8?
I am okay with that as long as I understood that is a purchase receipt and not like a ordered receipt. That was a potential order pickup. I did not pick up on that date, but that was what that was.
Well, it kind of confirms that you ordered it. Yes.
No objection.
Okay. All right. In that case, that'll be entered as exhibit number 8.
Moving forward, do you have concerns with regard to Mr. Granley's judgment going forward?
Yes, I do.
Are you aware of Mr. Granley ever supplying marijuana or any other substance to minors?
Yes.
Can you please explain to the court what you are aware of?
At the end of July of 2023, Chris made a trip back out to Nebraska to visit some friends. I was informed by one of my best friends after that visit that Chris had brought marijuana with him to Nebraska and had given it to her son.
Is this something that you ever discussed with the defendant?
Not directly.
Okay.
Miss Watts Day, I guess I should ask who the third person is in the room.
This
I
is a friend of Ms. Granley's. We are not calling her as a witness. She is
Okay.
just here as support.
I wasn't sure because I
Yeah,
should have
I'm
asked
sorry.
that
I
earlier.
should have clarified that at the beginning that no, we
Yeah.
are not calling her as a witness. She's just here as moral support.
Well, and the court allows people to be in the courtroom as moral support as long as they're not on the main screen. At this point, because of the room configuration,
Yeah, I don't know how to
I'll
put her somewhere
yeah,
where you wouldn't see her.
I'll continue to allow it
Okay,
at
if you
this
want,
point.
I could probably have her go like into the corner and then
No,
go
well,
beyond the screen.
a lot of attorneys bring an assistant or somebody who's shadowing or a second chair, basically.
Yeah.
I just realized, okay, I've got 3 people in there, and
Yeah,
I've
no, my
kind of
apologies. I should
because
have clarified that at the beginning.
well, I've been concentrating on the issues of the case and not that specific one. So, no, at this point, I will allow it just as I would allow. And Mr. Greenlee, I would have allowed your girlfriend to stay if she wasn't being called as a witness because she can. But you got your support animals, so you have your support.
And I have a question, Your Honor.
Sure.
At some point, could we get a brief recess so that my girlfriend and kids, we can just transfer to a new spot?
Yeah, of course. When do you want to do that?
We're just parked right here. They're kind of waiting outside. They went to a store, okay, shopping. Just wanted to know if we could go.
Okay.
But just after,
If you wish, we can recess for a few minutes and let you relocate.
Absolutely. If we can wait till after Ellie, if that's okay.
That's fine. Okay, we'll recess a moment and let you go do. Miss Granley, you are still under oath. Miss Watts Day, if you could proceed, sir. Proceed, ma'am.
Thank you. Ellie, did you in August of 2023 attempt to have a meeting with the defendant with regard to the separation and where you guys were?
Yes, I did.
Where did that occur?
That occurred at the condo that we had been renting at the time that Chris was still living in.
Was anybody else present?
Vince and Lauren Dixon, our friends, were also present.
What occurred during that meeting?
A lot of discussion and back and forth between Chris and I, and him trying to explain his actions. Halfway through that discussion, I started getting up to prepare to leave. I was through with the conversation and I wanted to leave. Chris ended up cornering me in the kitchen, backed me into a corner in the kitchen, and would not let the discussion end.
Okay. That was on August 6th of 2023, is that correct?
That is correct.
And was there any correspondence via text between you and the defendant following that meeting?
Yes, I did receive text from him following that.
And I'm gonna ask you to look at Exhibit 8. Are these the texts that between you and the defendant following that meeting?
Yes.
And what, if you can summarize for the court, what was said?
This is Chris texting me, admitting to instances where he had been lying, as well as intimidation and manipulation going on as well.
We would move for the admission of Exhibit 8 as the court Exhibit 9.
Mr. Granley, any objection, any comment?
Yes, no objection.
Okay, no objection. Exhibit 8, the proposed Exhibit 8 will be entered as Court Exhibit 9. All right, please proceed, Miss Watts Day.
Thank you. During that time, was Chris exercising parenting time with CJ?
Yes, he was still having approximately 2 days a week with CJ because of his work schedule versus my availability and work schedule. That was the time that worked best for us at that point.
And were you making any observations with regard to how CJ appeared after parenting time? Did you have any concerns with regard to the parenting time?
Yes, it was noted by me and our friends as well that there was concerns for what CJ was being fed during Chris's time, as well as his physical appearance, specifically the fact that he was always smelling strongly of urine.
Okay. Did that continue as he continued to have parenting time?
Yes, it did.
So that was not a single incident.
No, it was multiple times that it was noted that there was a very strong odor of urine during his time.
Did you have another altercation with the defendant in September of 2023?
Yes, September 16th of 2023, Chris was preparing to move out of the condo that we had been renting. He was going to move into his own apartment. And he ended up texting me asking for help with that move out process, that he was not prepared. He had, I think, 2 days left at that point to move out, and he was having trouble finishing, and had texted me to see if I could come over and help. So I did go to our condo at that time. I was 8 months pregnant by now. Chris asked during that visit what else needed to be done to have the condo ready so we could get our deposit back. I let him know what things needed to still be cleaned and done. He got very upset and angry, and was yelling at me. I ended up leaving because, again, I did not feel safe. And I called my friend Lauren after I left because I was very upset and I was having trouble calming down from that altercation.
Was there an incident in October of 2023 with regard to parenting time?
Yes.
Can you please explain to the court what occurred at that time?
By October 24th, 2023, Chris and I had come to an agreement for the divorce. My lawyer had actually written up a judgment that we both agreed to and signed. We both signed that judgment on October 24th. Part of that agreement was that we would not transport CJ outside of 100 miles.
Wait. We have a judgment that's been signed by both parties?
It was not submitted to the court.
It was signed, and then there were this was before a case was filed.
Oh,
it was
okay.
Signed,
Okay, never
and then
mind.
there was the subsequent, she's going to provide testimony that led then to the filing and how things have progressed since then.
I apologize. I just wanted to interject because I'm like, if we got a signed judgment, we're done. But yeah, if it was before, I didn't realize the timing. I apologize. Yes. Okay, I'm like, I'm sitting here going, why are we doing this? We got a signed judgment. Okay, never mind. Confused.
That's okay.
I'm following along and I'm writing notes and I'm like, okay, never mind. Proceed. I apologize. I just got like my heart just stopped.
This was an agreement that Chris and I had come to without filing for divorce the traditional way, because we were trying to keep things as calm as possible. He was still living in Michigan at the time, so that was what that agreement was based off of. Part of that agreement was that CJ would not be transported outside of 100 miles from our homes, and that there was a 6-month waiting period to introduce them to any significant others for his well-being. Within a couple days of signing that agreement, Chris, during his time with CJ, ended up taking him out of state to Chicago to introduce him to his girlfriend. As a result of that, the agreement that we had just
hold on. We just lost Chris.
I am a little concerned. It looked like he froze for a while there, but it appeared that he may have been driving too.
No, he said he was not driving. It looked like he was in the passenger seat, but I didn't notice he froze. So hopefully when he comes back, because he did say when he came back in, he's not driving.
Okay. It looked like there was things going by, so I'm wondering if someone else was driving.
Yes, I think someone else is driving, and that could be a problem now that you just mentioned it, because that would be a witness he's wanting to call. Yay.
So sorry about that. Just a connection issue.
Yeah. Well, Mr. Granley, you said that you're with your girlfriend and her kids. Is she driving?
She is driving. I'm no longer.
You said you may request to have her called as a witness. No. We need to stop this at this point and get you pulled over and get her out of the car, or you need to get to your destination. How long is that going to take?
About 5 more minutes.
Your
All right,
Honor,
we're
I mean, honestly, I object to this. This is the day and time set for this hearing. This is a trial. We
Yes,
don't
it is.
take breaks so that people can drive to different locations. He should have been where he was supposed to be at that point in time. My client wants to get this case resolved, and the defendant has completely delayed this, where she has attorney fees.
Okay, then let me ask this question. Has he had any parenting time? Anytime in
Yes, he had parenting time last weekend.
what
Supervised parenting time
supervised?
based
So
on the agreement.
his parenting time is supervised as agreed. Child support is reserved, correct?
Correct.
So this all goes against him, not against you.
But
Because his parenting time will stay supervised. It's not going to get any better. Yes. Yes.
Trying to get this
And
case
I may have to address that issue. At your request, I may have to address the issue of attorney fees. But I'm going to give him 10 more minutes. So we'll recess for a moment, and thank you for noting that. Please do not forget it, because if we have to go to another day, I might. Even though I rewatch these hearings, I will try to remember that there is attorney fees on the line here, sir. So get to a place where you're safe and we can talk. Yeah. All right. Get there. Okay. We'll recess a moment. She said never again. Basically, it was a dad's weekend for college for my daughter, and I screwed up, and I had a hearing that afternoon, and she's like, well, we promised our daughter we'd be there for dinner. And I'm like, I got a hearing from 2 to 5. And my wife's like, she goes to Indiana University. That's 5 hours from her house.
Wow.
We're not feeding her dinner at 11 p.m. So in consequence, I wound up doing a hearing from the backseat of a car, which everybody didn't really notice because I have the same fake background on my phone, except every once in a while I did this. And then I also had a sash from here to here, which was the seatbelt. But that's what Zoom is. And Mr. Granley, I'm sorry, but we cannot have the witness in the car. Okay. It does allow her to ask for attorney fees for any delays. So we're back on the record in the matter of Granley versus Granley. Ms. Granley, you are still under oath. Please proceed, Ms. Wattsday.
Thank you. Ellie, you were providing testimony with regard to an incident that occurred on October 28th of 2023. I think you, if I could summarize, just testified that the defendant had left the state of Michigan without your knowledge, contrary to an agreement that the two of you had reached just days prior. Did he acknowledge initially that he had left the state?
So that morning of October 28th, he had told me that they were going to be here in town doing trick-or-treating. I found out through our joint bank account that he was in Chicago and confronted him over text asking where they were. And he continued to tell me that it was none of my business and that it did not matter where they were at the time.
I'm going to ask you to look at what is marked as Exhibit 9. Is that text message that was between you and the defendant?
Yes, it is.
On the day in question?
Yes, that from that weekend.
Okay. And that's what you were referring to. He simply refused to respond and would not provide information?
That is correct.
Okay. We move for the admission of Exhibit 9 as court's Exhibit 10.
Mr. Granley.
No objection.
All right. In that case, that will be entered into evidence at this time.
Did you speak with with the defendant on that day?
I texted him briefly. He then informed me that his phone was dying and I did not hear anything else from him until he dropped CJ off late that night.
Okay. And how did he appear when he dropped him off? What was his demeanor?
Very anxious. He was speaking very rapidly. Some of his speech was slurred. I tried to get information on whether or not CJ had taken a nap that day or when he was last fed, and it was just very unintelligible what he was trying to say.
I'm gonna ask you to look at Exhibit 10. Is that a text exchange between you and the defendant's mother?
Yes, it is.
Can you please summarize that for the court?
This is a conversation I had with his mom, saying what was going on, that Chris would not tell me where they were on that day, and her acknowledging that.
I move for the admission of Exhibit 10 as the court Exhibit 11.
Mr. Granley.
No objection.
All right, that'll be entered into evidence at this time as exhibit number 11.
I'm also going to ask you to look at Exhibit 11. Is that a picture that you took?
Yes,
And when did you take that picture?
I took that picture the following morning, so October 29, 2020.
And what does that picture depict?
That is the sippy cup that Chris dropped off with CJ. That was the sippy cup that CJ had with him in the car on that Saturday.
And are you concerned about the state of that sippy cup? And if so, why?
Yes, there was mold growing on the sides of that sippy cup,
On the inside of the sippy cup?
on the inside.
Okay. And it's your understanding that was a sippy cup that your son had been using the day before?
That's correct.
I move for the admission of Exhibit 11 as Court Exhibit 12.
Okay, Mr. Granley, any comments?
Just the objection. That's not my. I didn't purchase that sippy cup. That's not one that I used. So I'm not sure whose that is, but
Okay,
that's
so
not my personal
this
sippy cup.
this was not one that was used while the child was with you.
No,
Okay,
I use all the same brand. I still currently have all the same brand sippy cup. That could have been one that was in the car or just one that got replaced, but that's not. We had went to Chick-fil-A that day for lunch. He had not needed a sippy cup. He had a bluey tin can. So no
Okay.
objection that that's a picture of a cup. A picture of a cup.
what I'm going to do is enter it as a picture of a cup, but Miss Granley, you're going to have to show that that was the one that was used. So we'll enter it as pretty much an exhibit, but he does, and Mr. Granley, you're going to have to cross-examine on that. So please take a note that you got to bring that up because, but the cup was with him to your knowledge, Miss Granley.
Yes, Chris had CJ's diaper bag with him, and that cup was in the side pocket of the diaper bag.
Okay, but you have no knowledge as to whether that was the sippy cup used during that weekend.
I just know that that's the sippy cup that he came back to me with.
Okay, but it was also the one that you sent him with.
No, that came from Mr. Granley's home.
Oh, okay. Why is there no lid on it?
That was when I took the lid off to dump out whatever was in it so I could put it in the dishwasher, and then I noticed that there was mold on the inside.
Okay, sorry, I'm just trying to make a record as to trying to figure out what that is, what it means, and does it mean anything or does it mean a lot? Okay, so I'll enter that as an exhibit, but at this point in time, it is, as all the exhibits, they're under cross-examination. Please do not forget that, Mr. Granley, because you have to take notes, and this is what, if you forget it, when I rewatch this hearing to make a decision, sometimes testimony is elicited and then not contradicted. So it becomes testimony of the court. Okay.
Yes, sir.
And I understand your concerns, Ms. Granley, but let's find out if it was actually used or not too. I get it. You get that back and you're like, what the, but in any event, let's proceed. That'll be entered as a court exhibit number 12, and it was the proposed exhibit number 11. Please proceed, Ms. Watts-Day.
Thank you. So just to clarify, Ms. Granley, the sippy cup that was in that exhibit does not belong to you, correct? Was it sent by you with CJ for that parenting time?
No.
Had you ever seen that sippy cup before?
I knew that it was one of our previous sippy cups that Chris had kept in his possession.
Okay. And that sippy cup was in the diaper bag when it was returned to you?
Yes,
Did you remove it from the car and put it in the diaper bag?
I did not.
Okay, so it must have been Mr. Granley that put it in the diaper bag?
That is correct.
Moving on, did Mr. Granley indicate why he had gone to Chicago?
He told his friend Vince that his only point to go to Chicago was he just wanted to go have fun.
Okay. And was anybody else in Chicago?
I did not know at the time if anyone else was there. Chris confessed to me at a later date that he did go there to meet his girlfriend.
And this was contrary to the agreement that you guys had just made that you would not expose the children to any significant others for a period of 6 months?
That is correct.
When you observed Mr. Granley that day when he finally returned CJ, did you believe that could you, based on past experience, make a personal observation on whether or not he was taking meds or whether he was consistent with his treatment?
Based on what I observed from him and the actions that were made that day, to me, it was very clear that it was a manic episode, which he does not have when he is stable on his medication.
After that incident, did Mr. Granley return to Pine Rest?
Yes, he did.
And what is your understanding of what occurred while he was at Pine Rest?
Pine Rest told Chris that he was spiraling in a manic episode, and they recommended more treatment.
Okay, I'm going to show you what's been marked as Exhibit 12. And is this text message from the defendant?
This is from Chris, yes.
Okay, and what does it state?
This is a conversation between him and his friend Vince. This is Chris saying that he knows that there's an issue, that he's not well. Chris says directly that he's spiraling and that he can't recognize when it's happening.
I'm going to move for the admission of Exhibit 12 as Court Exhibit 13.
Mr. Granley.
No objection.
All right. Exhibit number 12 will be admitted as court exhibit number 13.
I'm going to also refer to you on Exhibit 12 to the third page. Is that a text message between you and Mr. Granley?
Yes, it is.
And in that, is he acknowledging that there was an issue, and is he bringing you up to speed on the change in medication, et cetera?
Yes, this is him letting me know he had another appointment with Pine Rest, that they are adjusting his medication, that they believe there's still an imbalance going on, and that he recognizes that that needs to be fixed.
At this point in time, was the defendant still living in Michigan?
Yes, he was.
Okay. I want to refer back to Exhibit 12 just for a second. On that second page, does he indicate, is the defendant indicating that he's resigning from his current employment?
Yes, on November 9th, he texted, this is a text to his friend Vince, that he is going to resign from his position.
Okay, so he was voluntarily leaving, stating that he knows it's the right thing to do?
That is correct.
After he resigned from his position in at Cornerstone, what did he do next?
I was made aware that he was planning on moving to Indiana to move in with his girlfriend.
Okay. Do you understand, or what was your understanding as to why he was making that move?
I was not clear from him what the reason for the move was. I had reports from other people. He said that he wanted to move for his mental health. He said he needed to move because he couldn't find a job here. One report was that he felt unsafe because his motorcycle was stolen.
Okay.
All right, hold on. I heard a sneeze. Who sneezed? Was it a dog? Okay, never mind. That could happen.
It's not
Never.
bad, yeah.
I just wanted to make sure because I didn't see anybody on Miss Watts' Day's thing kind of go achoo. So okay,
Yeah,
never
that's not-
mind. All right, that one's
That's my
okay.
buddy.
No problem. Bless you, dog. In any event, I just wanted to make sure there was nobody else present. Forgive me. This is being recorded, and I just want to make sure we have a clean record. And if there's anything that's untoward, I need to point it out and or correct it. So the correction is, bless you, dog. Miss Watts Day, forgive me for the interruption. Please continue.
No problem. Okay, so one of the alleged claims was that he couldn't afford to stay there, he couldn't find employment, but in fact, he just voluntarily quit a job, correct?
That is correct.
Okay. And with regard to, a claim that he felt unsafe because his motorcycle was stolen, are you aware of whether or not that could be accurate?
After he moved to Indiana in December of 2023. I discovered driving by his previous apartment that the motorcycle had been abandoned there. And I have pictures of the motorcycle up to, I believe, April of 2024, that the motorcycle had just been left behind.
Were there any incidences in December of 2023 that caused you to be alarmed about the defendant's state of mind?
On December 9th of 2023, he called his friend Vince, who had previously taken the guns that Pine Rest said he needed to turn over during that time. He demanded all of those firearms back. He gave Vince about an hour notice that he was going to be coming by for them. Vince let him know that he was very uncomfortable with the situation. He was not sure that Chris was stable and should have the firearms. Chris showed up at their doorstep with a police officer in order to get his guns back.
And I'm going to ask you to look at Exhibit 13. Is that the text messages from Chris asking for those firearms?
Yes, this is a text message from Chris to Vince saying that he needs those firearms because they believe that his girlfriend and girlfriend's kids are in danger from her ex.
Okay. I'm going to move for the admission of Exhibit 13 as court's Exhibit 14.
Mr. Granley.
No objection.
Okay, Exhibit 13 will be entered into evidence as Exhibit number 14. That went a different way. I figured you were talking about hunting season, but
Right.
just timing. It is Michigan. There are courts that actually recess for November 15th, so it's kind of like a holiday in certain northern parts of Michigan. Anyway, that'll be entered into evidence as Exhibit number 14.
Ms. Granley, following the incident that had occurred at the end of October with CJ and the defendant's removal of him from the state of Michigan, did you make a decision about proceeding with the divorce?
At that time, I decided it would be in everyone's best interest to file for divorce in the traditional way, because we were clearly having a disagreement over custody and parenting time and what was best for the kids.
Did you experience, is it accurate that we filed a complaint for divorce on or about November 14th, 2023?
That is correct.
To the best of your recollection, did we experience difficulties with getting the complaint served on the defendant?
Yes, we did.
And to your recollection, what were the issues?
He would not give us an address for where we could serve him. We asked if we could do it electronically to be done in a timely manner. He refused, said multiple times that I could not contact him on that any further, that he was going to get a lawyer and he would not be doing anything until we heard from his lawyer.
Do you recall when we were finally able to get him served?
I don't believe we got him served until the beginning of February in 2024.
And how did we finally have to serve the defendant?
We used a local police officer as a
Process server.
process server.
During that period of time or after the October 28th incident, what was your message to the defendant with regard to the parenting time issues?
At that point, I made clear to him that I was encouraging him to have as much parenting time as he wanted, but because of the events that have taken place, that I was not comfortable with that being unsupervised time.
Did you ever encourage the defendant to obtain, I guess, medical help, mental health help, with regard to how parenting time would progress?
Yes, my only request to him moving forward with parenting time was that he was stable on his medication and not using marijuana, and then that he could prove that consistently. That was my only requirement for him to have unsupervised time.
Was that information provided to the defendant on multiple occasions by you?
Yes.
I'm going to ask you to take a quick look at what's marked as Exhibit 14. There's about 25, well, I shouldn't say about, there are 25 pages to Exhibit 14. I'm not going to ask you to go through every single page, but is Exhibit 14 text exchanges between you and the defendant?
Yes.
Can you briefly provide sort of a summary of the types of things that you guys are addressing through these text messages?
Mostly involving parenting time, as well as a couple of financial issues. It is Chris asking for what he needed to do to see the boys, and me communicating that once again, my only requirement for him for having any unsupervised time was being stable on medication and refraining from using marijuana.
We're going to move for the admission of Exhibit 14 as Court Exhibit 15.
Mr. Granley.
No objection.
Unfortunately, at this point, the court's going to have an objection. These look more like settlement negotiations, Ms. Watts-Day. I'm not sure the court should enter them as an exhibit. This looks like a negotiation between the parties from what I'm looking at. And I am uncertain, so please address that. I understand these are issues between the parties, but at the same time, forgive me, I quickly read through them because they were just presented to the court. Well, the court's had them, but I don't look at them until they're entered. But at the same time, I'm kind of grasping some of these pages, and they almost look like settlement negotiations, which disturbs me. The issues before the court are the issues before the court, but at the same time, nothing that entails settlement negotiations pursuant to court rule and statute should ever be entered. So please, why am I accepting this?
I would tell the court I would not view these as settlement discussions. My client makes it very clear throughout all of the text messages that she is not engaging in settlement discussions, that if he wants to have those discussions, he needs to go through his attorney, or if he was not represented at the time, that he could communicate directly with me as her attorney. What these are is, he's reaching out saying, I want to have time with children. And she's saying, that's fine, but my requirements have not changed. This is why this is how I would be okay. There's also
and those in accordance to Chicago terms, those kneecaps look really nice. It'd be a shame that something would happen to them while we're talking about it. I'm looking at this going, I'm sorry, I'm not entering that. I thought about entering it and going, there's no jury here. Hearsay doesn't apply. But I really have a strong problem with people trying to negotiate things and having that entered to the court. While there's no objection, the court has an objection, and I'm not entering that as an exhibit. So please proceed. I want to keep this on equal footing, and I'm not going to have them doing these yeah, I'm not negotiating, but I'm negotiating things. And 25 pages of that, no. So, entry of that exhibit denied. Please proceed, Ms. Watstay.
Sure, Your Honor. I'm going to show you what's marked as Exhibit 15. Is this a document that you have created?
Yes.
And where did you, how did you come about this information?
Through reviewing text messages between Chris and I.
So what does this document summarize?
This summarized every time between November 2023, so November 11th, 2023, through present of every time that I offered him time or a visit to see the kids, as well as the ones that he accepted or ignored.
Okay. So you understand that defendant's position seems to be that you somehow withheld the children from him, correct?
Correct.
And is this representative of the offers that have been made, what occurred, whether he responded, and if they did occur, what kind of visitation occurred? That's correct. We look for the admission of Exhibit 15.
Mr. Granley.
I'm pulling it up real quick.
Yeah, that one's appropriate. So we're going to enter exhibit number 15 as exhibit number 16.
Yep.
Okay. Thank you. Please proceed.
I'm going to show you what's marked as Exhibit 16.
Yes.
What does this exhibit represent?
This is a summary of our FaceTime schedules. We attended mediation in August and both came to an agreement of twice a week FaceTime schedule that would be consistent for the boys. And this summarizes the FaceTimes that were scheduled and then were not made.
Okay. And have you consistently made the boys available for FaceTime based on your understanding of the agreement that was reached?
Yes.
And consistently has Mr. Granley made himself available, or has he attempted FaceTime?
No.
Have you communicated to Mr. Granley that you would be willing to look at other dates or times if he could be consistent with them?
Yes.
Has he ever provided an alternative suggestion that he could be consistent with?
We did 2 different schedules. We had the original schedule that we agreed to in August for Tuesdays and Thursdays. He later texted or communicated that he was not available on those evenings. I then offered him Monday evenings as a consistent schedule, which he again agreed to, and then never followed through.
We would move for the admission of Exhibit 16.
Mr. Granley.
My only objection with that is that on several occasions, the plaintiff had blocked my phone. So as I was trying to call and set up different things to get things squared away, a lot of times.
That's not
Hold on. Let him make a record. And
just several times the phone was blocked. That's all, sir.
Yeah, and that's not an objection to the entry of this exhibit. Okay. This exhibit will be entered. I'm going to deny your objection and say you may cross-examine on it or enter other things that show that you were blocked.
Yes, Your Honor.
Right. Thank you. So, okay.
Yes, sir.
Just trying to keep this fair and a level playing field. All right, Miss Watstay, please proceed. But that will be entered. That is exhibit number 17, which was your exhibit 16. Thank you. I really wished we could have gotten back on the right numbers, but oh well. Even though I denied exhibit number 15, we're still moving on because exhibit number 15 is marked as denied. One off.
Right. I'm going to ask you to, Ellie, to review exhibit 17. This is the supervision agreement that was signed by both you and the defendant, correct?
Correct.
That was also signed by the supervisor in this case?
That is correct.
Okay. Has Mr. Granley exercised parenting time under this supervision agreement?
Yes, he has.
And when did that first occur?
Just this past weekend.
Okay. And this agreement was just signed finally at the end of October, correct?
That is correct.
Are you comfortable moving forward with parenting time under this agreement?
Under this agreement, yes, I am.
And what is your understanding of the parenting time that has been agreed to based on everybody's schedule?
Like when it would occur?
Yes.
My understanding through this agreement is that the parenting time would occur the fourth weekend of every month.
Okay. To be clear, were you willing to allow parenting time, or would you have encouraged parenting time prior to what occurred just this past weekend? Had this agreement been signed before?
Yes.
When was, to the best of your knowledge, when was this first presented to the defendant and his attorney?
Mediation that we had in August.
Okay. Was there, to the best of your knowledge, was there any issue on your side that would have prevented signing and entry of this agreement before it was actually signed?
None.
Did you ever refuse to sign it?
No.
Did you ever take the position that it needed to be modified or changed?
No.
Are you aware, or what is your understanding of why it wasn't signed until October 30th?
For Chris, we had an agreement at mediation for this parenting time schedule. Chris informed us after mediation that he no longer agreed to it. He had issues with it, and then it devolved from there.
We moved for the admission of Exhibit 17.
Any objection, Mr. Granley?
No objection.
That'll be entered as exhibit number 18 as exhibit number 17. Or proposed exhibit 17 as exhibit number 18. So, all right. Please proceed, ma'am.
In moving forward, I want to talk a little bit about parenting time and the best interest factors. So I just want to clarify for the record, do you have any objection to you and Mr. Granley sharing joint legal custody?
No objection.
And you understand that that would mean that you two need to communicate as it relates to any important decisions that impact the boys' medical, education, religion, etc.
Yes.
Is that something that you've been doing?
Yes.
Do you have examples of where you've shared information with the defendant?
Our youngest son, Miles, has had some medical issues in the last year. Anytime that there has been an update with that condition, I have informed Chris what was going on.
Does Miles have an upcoming procedure?
Yes, he has a procedure next week.
And is that something that you made Mr. Granley aware of?
Yes.
Is he welcome to attend if he chooses to?
Yes.
Have you shared with Mr. Granley the expenses associated with that procedure yet?
I have not.
Okay. What have been your expenses associated with Miles' medical procedures?
I have paid his deductible for all medical procedures at this point, and the therapy that he was involved in for it. I have paid the deductible out of pocket. And now starting for this procedure next week, I will pay the 20% co-insurance.
Okay. What has been the out-of-pocket expense to meet the deductible?
To meet the deductible is $2,000.
And is that something that you are requesting the court? Well, let me back up for a second. You are not receiving child support, correct?
Correct.
What is your understanding of the court's order from May of 2023 regarding child support?
The court did not put in an order outside of saying that it needed to be referred to front of the court because Mr. Granley was reporting that he was unemployed at the time. The judge's decision at that point was that they did not want to put in an order to put undue stress on him.
Now, she did indicate, however, that child support would be retroactive back to December of 2023, correct?
That's correct.
Is it your request that the court?
I apologize. What date?
December of 2023.
Okay, thank you. Okay. And that was Judge Bryant? that did that?
Correct.
Thank you. Okay.
Uh,
Thank you.
There
Thank you for
is
the
an
qualifications.
order, sorry, just for clarification, there is an order in the court file, an order of reference that was dated May 24th of 2024. Referring this to the friend of the court for child support with a retroactive date. It says starting 12/1/2023.
Thank you.
Is it your request that in addition to the child support, that the court order, depending on what the appropriate percentage is, that Mr. Granley contribute to the expenses that you've already incurred on behalf of the children from a medical standpoint, but also any future expenses?
Yes.
What is your understanding of your out-of-pocket expense for the procedure that's occurring on December 4th?
I have been informed that the 20% coinsurance for the procedure next week is $3,600.
And you will provide documentation with regard to that if necessary?
Yes.
Okay, but you don't have that at this point in time?
They
because it
just
hasn't
informed
occurred.
me on Monday what the cost would be.
With regard to the best interest factors, you do understand that the court has to look at the best interest factors as it relates to the boys in determining custody and parenting time, correct?
Yes.
The first factor is the love, affection, and emotional ties between the parents and the children. Do you have an opinion as to which one of you might have a stronger bond or emotional ties with the boys?
I would say at this point in time that I have a stronger emotional tie to the boys.
And why is that?
They have spent, Miles has spent all of his time with me, and CJ has spent the vast majority of his time with me.
And again, from your perspective, you believe you've offered opportunities for the defendant to spend time with the boys, correct?
That is correct.
For the vast majority of those opportunities offered, has he accepted that?
He has not.
Okay. Who provides for the boys' daily care?
I do.
And what exactly does that entail?
Getting them up in the morning, feeding them, changing them, getting them dressed, taking them to daycare, or some days they stay home with me as well. Any physical or emotional needs go through me.
And do the boys turn to you for their emotional needs?
Yes.
Okay. Do you have concerns with Chris's ability to contain his temper and not show anger or frustration around the boys?
If he is unstable on his medication, I have very strong concerns of that.
Okay. Do the children ask for their father? Do they seem to miss him? Are they, what are you observing as far as their relationship with their dad?
CJ is the only one talking at this point. I have not heard CJ ask for him or mention him. If we have a visit scheduled that I know is going to happen, then usually the night before, I start letting CJ know you're going to go see dad tomorrow and kind of prepare him in that way. So he is aware when Chris comes to pick him up or we have a supervised visit that he knows that that's dad during that time.
And Miles, obviously with the age, I don't know what's going on with Mr. Granley's screen. Okay. Due to Miles's age, there's not a lot that you've been able to observe as far as any interaction or relationship with the defendant?
That's correct.
Okay. With regard to capacity and disposition of the parties to give the children love, affection, and guidance, how do you provide the children with love, affection, and guidance?
Just time and attention.
And do you believe at this point in time that the defendant has been able to, or that he has provided love, affection, and guidance?
Not in an appropriate way at this point.
Okay. Do you think he could have, even given the separation, logistics, et cetera, could he have, if he had chosen to been in a position to provide those things to the boys.
Yes, absolutely.
How do you think he would have been able to do that?
He informed us for a significant period of time of this year that he was unemployed and that he had a large amount of availability to be there for the kids. But despite that information that he provided, he was still not accepting the visits that I offered to see the kids.
What activities do you engage in with the children?
They go to daycare 4 days a week. Outside of that, we like to spend a lot of time outside, going to the park, playing with the toys together, and anything that involves connection between the boys.
Do you have concerns that the defendant is engaged in activities that impair his ability to exercise good judgment?
Primarily the marijuana usage.
Okay. And not being consistent with his medication?
Correct.
Okay. With regard to the capacity and disposition of the parties to provide the children with food, clothing, and medical care or other remedial care, who provides for the kids' basic needs?
I do.
Who provides medical insurance?
I do.
Who schedules and takes the children to doctor's appointments?
I do.
Has the defendant engaged in any of that since you two separated in June of 2023?
He has not.
Has he had the opportunity to, if he chose to?
When he was living in Michigan, I would let him know of any appointments and he was welcome to join.
Did he ever join?
No.
Has the defendant provided any financial support since the two of you separated for the benefit of the children?
There was a couple of small gifts early on, but no significant support.
Okay, and when you refer to gifts, what does that mean?
I would receive randomly a box of diapers, or at one point he gave me a bag that included vitamin gummies, a loaf of bread, and some Nutri-Grain bars.
But no financial support, no money?
No.
He has not used any of the income that he has made to provide you any support?
No, he has not.
What is your understanding of his current employment?
My understanding that currently he is working for his girlfriend.
Okay. Do you believe he's maximizing his earning potential based on past history?
No.
Do you have concerns with job stability based on his past history?
Yes, I do.
Oh, hold it. I'm sorry, I was muted. How old is the oldest?
He is 3.
Okay, sorry, I interjected when you mentioned the kind bars, I think it was.
Nutri-Grain bars.
Nutri-Grain. Are those made for 3-year-olds?
He's able to have them. They're not a significant part of his diet.
Understood. I'm just sorry. I was trying to put age appropriateness to the gifts that were given. And forgive me, I somehow, thanks to my big belly, I knocked the fob on this thing and muted myself. That's normally my clerk's job to keep me from talking. But anyway, I was just trying to, as we're talking, as I'm listening to testimony, I am trying to think about what I'm hearing. And I was trying to make sure that, because I thought they were very, very young. And I'm like, a Nutri-Grain bar sounded a little bit odd for a 3-year-old, but please continue.
Thank you. With regard to the length of time, the children have lived in a stable, satisfactory environment and the desirability of maintaining continuity, which is factor D. What is the kids' current environment?
They live with me full-time in a stable, calm environment.
Okay, and can you just describe your residence for the court so it can get an idea of their living environment?
Yes, we currently live in a townhome. They both have their own rooms. It is just me and the boys.
Okay. There was a short period of time that you did live with your parents, correct?
Yes, when I initially moved out of our marital home, I moved in with my parents because I was pregnant along the way, and I wanted to get past my maternity leave before getting into my own home.
And so when did you get into your own home?
October of 2023.
Okay. And Do you see a move in your future at this point in time?
I do not.
Okay. What is the defendant's living situation since separation, to the best of your knowledge?
He moved out of our marital home, which was the condo that we were renting. He moved out of there in the end of August of 23. He moved into an apartment in Kentwood. My understanding is that he lived there for about 4 months. And then in December, he broke that lease and moved to Indiana to live with his girlfriend.
And at some point in time, during that period of time, he also said he was going to live out of his car.
And right after I moved to my parents, when the separation first happened, his first indication was that he was going to live out of his car.
And the children have resided with you 100% of the time since the separation, correct?
Chris had CJ for 2 days out of the week between June and October of 2023. Outside of that, they have been with me.
Okay. And you've already testified there's nobody else living in your home besides you and the children. Do you know who is residing in defendant's residence? I know you mentioned he moved in with his girlfriend, but do you know anybody? I mean, do you have any specific knowledge about who all lives there?
I believe she has 2 girls. I do not have knowledge outside of that.
Okay. The factor E is the permanence as a family unit of the existing or proposed custodial home. It sounds like your testimony is you intend to stay where you are. And are you seeing anyone?
I am not.
Okay. Do you have, you can't obviously predict the future, but do you have any intentions of getting into another relationship in the near future?
Not a serious relationship anytime soon.
Okay. Do you have concerns about the permanence of the family unit as far as the defendant is concerned?
I do.
And why do you have those concerns?
He indicated that he was not in a relationship with his girlfriend for a very long time, that he would not be, and then that changed within a matter of 3 weeks that he ended up moving in with her. And there was just evidence of manic behavior or unrational thinking.
Okay. Were you aware, or had you been made aware at some point in time between December when he moved in there and now that he had supposedly had a falling out with her and was potentially leaving Indiana and moving back to Michigan?
Yes, 2 months after he moved in with her, so it would have been in February of 24. I learned that he had had some kind of a falling out with her, and he was thinking that he was going to come back. He wanted to try to repair things so that he could see the boys.
And what happened after that, to the best of your knowledge?
To the best of my knowledge, they patched things up and he still lives with her.
Okay. Factor F is the moral fitness of the parties involved. Do you use illegal substances?
I do not.
Do you have any sort of criminal record?
No.
Is there anything that the court should be aware of with regard to your moral fitness?
No.
Okay. Do you have concerns with regard to the defendant's moral fitness?
Yes.
Can you describe to the court what your concerns are?
The excessive marijuana usage and in regards to his medication, as well as providing that marijuana to minors.
Okay. Has the defendant, I mean, I think we've already addressed this, but I want to confirm, has the defendant either verbally or physically abused you in front of the children?
Verbally, yes.
Okay. To the best of your knowledge, does the defendant have a criminal history?
Not that I'm aware of.
Okay. Have you witnessed any verbal, emotional abuse by the defendant against the children?
In his limited time, I have not seen that, no.
Okay. Factor G, the mental and physical health of the parties. Do you have, well, I guess first, as it relates to your physical and mental health, are you healthy? I don't know what happened to Mr. Granley.
Oh, great. Sorry, I missed that
He just messaged me. His computer dropped audio. He's
Okay.
gonna log
get
off
him-
and back in again.
We'll get him right back. Sometimes I pay too much attention to one thing instead of the other. That's okay. I'm just realizing I didn't marinate the turkey at lunch like I was supposed to.